Welcome, everyone. I think more people will be coming, but I'd like to start on time, partly because we're recording this. We're putting up on SICE's website. And I'd like to welcome you all. Thank you for coming. The topic today, as I think you know, has to do with the war in Ukraine. It's a war that resulted from a unilateral invasion by Russia. And purported annexation of territory that the UN Secretary General and the UN General Assembly have declared violates international law. It also seems to be a war where one side, that is Russia, is intent on bombing the other side, Ukraine, and back into the Stone Age. Our precise topic is how Russia can be held liable, and I'll come to our panelists in a minute. They're both very highly qualified, and each will speak around 20 minutes, and then they'll have a chance to comment on each other's remarks, and then I'll open it up to Q&A from all of you. To my immediate right, Professor Chiara Georgetti is a professor of law at the University of Richmond Law School, and she's a senior fellow at the Columbia Law School's International Claims and Reparations Project. She writes on issues of international dispute resolution and has authored or edited 9 books and over 40 articles, including International Claims Commission, Righting Wrongs After Conflict. So she's very familiar with this topic. She has represented states in several interstate disputes, including in territorial and maritime boundary disputes and international investment disputes. She's a leading expert on International Claims Commission and acted as counsel at the UN Compensation Commission, which was right after the Gulf War, and on the Eritrea-Ethiopia Claims Commission. She's now working at the request of the Ukrainian government to think about different approaches to setting up mechanisms to hold Russia liable. So, welcome, Chiara. Brian Egan, he's a partner in the national security practice at a law firm, Skadden, Arps, Meagher, and Flom in Washington, D.C. He used to be a partner of my wife's, but we'll forgive him for leaving there. He advises clients on a wide range of complex legal matters, including issues involving CFIUS and national security investment reviews, export controls, economic sanctions, anti-money laundering, public international law, and cross-border disputes. Earlier in his career, he served in several senior positions in the U.S. government. He was the legal advisor at the U.S. Department of State, which is the highest international legal position in the U.S. government. He was deputy White House counsel and legal advisor to the National Security Council. And he was assistant general counsel for enforcement and information at the Department of Treasury. So you can see he can't hold a job, but he has a wealth of experience. So it's terrific to have both of them here. Before they start, I'd like to provide a little context. So I know some of you are experts on these things, but some of you are not. And so for those, just let me say like 5 points here, if you'll bear with me. First, there are 2 types of liability in this kind of situation. One is criminal liability, such as we saw in the Nuremberg trials after World War II, and the second is financial compensation. And I think you'll probably hear more about the latter tonight. Historically, there are many examples where compensation has resulted after conflict, but there are also many examples where they haven't. And so one question is, will this be in the first category or the second? When there are claims commissions or whatever they're called, tribunals, they tend to be set up after the fact because they're quite situation specific. So it's interesting that so much attention is being paid right now to that, and I think that bodes well, actually. The third point is that liability is very fact specific. So it's very important to have documentation about claims and about evidence. And a couple of efforts are already ongoing within the UN system, actually, in that regard. The UN Human Rights Council on March 7th, which, right after, March 4th, right after the invasion, set up a commission which made a report in October of this year detailing different kinds of and specific instances of human rights violations, which is one aspect of what liability and compensation might be for. And the General Assembly set up a less extensive committee as well. The fourth point is that the legal landscape can be highly complicated. Here we have a fairly clear idea that Russia has violated international law. The General Assembly has said that on several occasions, etc. And there are two cases in the International Court of Justice that Ukraine has brought against Russia. But just to give you an example of the complexity, those cases are not what you might think they were. The natural inclination would be to say, well, Ukraine is accusing Russia of violating international law by invading. It turns out that the most recent one has to do with the Genocide Convention and stems from the fact that Vladimir Putin said that Ukraine was violating the Genocide Convention and that was a reason it invaded. And so Ukraine has turned that around and said, well, that provides jurisdiction in the International Court of Justice to analyze whether we did that. And I'm sure it's hoping that that analysis will extend to Russia. But in the meantime, it did get the court to order provisional measures. So, but that's very creative lawyering. And it just gives you an idea of the kinds of issues that are involved. The final point is that the political landscape is also very complicated. And it's sometimes not very pretty, but it does affect how these things are formed and how they operate and then how they're terminated. So with that, let me turn it over to Chiara, and you can speak from here or you can speak from up there.
Thank you very much. Thank you very much, Dan, for organizing this, for inviting me, as for SAIS also for having this very important discussion. I think you're right that when Russia invaded Ukraine on February 24th, we all thought, well, so what's happening? We talked. There were some warning, but nobody really thought that it was actually going to happen. And this is such an egregious violation of international law that we as international lawyers all began to think, so what are the possibilities? What should we do? When Russia invaded Ukraine almost a year ago, the violations were many. And so, of course, they committed the crime of aggression, first of all. But then many other international norms were also violated. And these injuries were caused to many different kind of actors in international law. So were caused to individuals, to the states, to many kind of states, to companies, so sovereign entities also. And the injuries included many different kinds of injuries also. So massive displacement of people, enormous economic and personal harm, widespread damage of public and private property, cultural property, and many other kind of damages that occurred. And as Dan also mentioned, I will focus my remarks on the liability for financial compensation rather than a criminal liability. But one of the principles that really guides international law is that when international law is violated, there's consequences. There are consequences where international law is violated, and a state that violates international law has the obligation to provide reparations. This is very well stated. This is a norm of international law stated in the draft article, the articles on state responsibilities. And this is something that is widely accepted. But what kind of reparations? What are the reparations that are really possible under international law? As was mentioned, I have the honors to serve in a working group that was established by President Zelensky in May 2022 to, as I quote here, to develop and make proposals on the means and legal instruments for compensation for damages and losses caused to Ukraine as a result of the armed aggression by Russia. So we started thinking, what are the different possibilities? I think the idea that most strike to us is the one to create a claims commission, similar to what has already occurred in many, many instances in the late 1800s and beginning of the 1900s, but more recently in three very interesting examples. The examples of the United Nations Compensation Commission, the Eritrea-Ethiopia Compensation Commission, and before that, the Iran-US Claims Tribunal. So what I would like to talk briefly about is first why a claims commission and what are the reasons that might bring why do we need a compensation commission, what it would do, and what has been done already, because in fact we already starting working on this, and we have some interesting results. So as to the why, although international law says, yes, there is an obligation for reparation, the instruments that actually exist under international law are very limited. So we heard, for example, the International Court of Justice, but the International Court of Justice has very limited jurisdiction, has a limited jurisdiction that is limited by treaties, so by subject matter, but also by personal jurisdiction. So you can only hear cases between states and not cases brought by individuals. And here we have different kinds. We have injuries to individuals, companies, Ukraine itself, and so we want something that is capable of hearing and compensate all these different kinds of claimants. So there's no really system that exists at the moment. So there is the International Court of Justice, not really viable. There is the possibility maybe and there are, together with the Human Rights Council and the and other claims and other commission of inquiry, we also have a case now, the International Criminal Court. But this is the criminal part, but is not really something that provides compensation. A claims commission can be created, can be targeted, and can provide ad hoc remedies to very specific situations. And so it is very flexible, and it's capable of resolving numerous and very complex cases. So I mentioned the three claims commissions that have existed in the past. And here I think it's quite interesting to think about what they have done. In terms of both how they were created and what they've done in terms of jurisdiction and the compensation that they provided. I'd like to just spend a few moments talking, for example, about the United Nations Compensation Commission. That was created by a Security Council resolution, and here, of course, we don't have that possibility. The Security Council here is not an option, of course, because Russia has a veto and will never allow that. But there are also other options. So the Eritrea-Ethiopia Claims Commission, for example, and the Iran-US Claims Tribunal are both created by treaty. But what the United Nations Compensation Commission actually did was very interesting, because it provided compensation to millions of people, millions of individuals that had to flee Kuwait because of Iraq's invasion of Kuwait, and provided compensation that were of two kinds: either a set amount of compensation for those individuals had to flee Kuwait and had a very specific kind of injuries, and those amount were set and were also provided as mass claims remedies. So this was very interesting, and these again were millions of claims that provided billions of dollars of compensation, and then also heard more complex and difficult cases brought by states and the states in the region. Kuwait itself, but also Saudi Arabia, Jordan, Syria, and others, that against the state. So these were intrastates. So the United Nations Compensation Commission had jurisdiction on both states and individuals and international organizations, and was able to provide very substantial amount of compensation. Similarly, also to a smaller scale, but similarly, another success story is the Iran-US Claims Tribunal, that they are provided limited for 4,700 claims between the government and nationals of Iran and the United States, and awarded 2.5 billion. And here again, you have a claims commission here called the tribunal that had jurisdiction for both claims by individuals and by the states. And I cited also the Eritrea-Ethiopia Claims Commission. This is a little difficult, it's a little different. Here it's interesting because you have two countries that were at war, and the war unfortunately caused very substantial damages. And when the war ended, we were able to, in the peace agreement, decided to create several different claims commissions, a boundary commission and a claim commission. And what is interesting here is that the claim commission had jurisdiction also over injuries caused by violation of a humanitarian law. And what I think is interesting when you look at claims commissions is that you have a variety of different kinds of claimants. So you have the flexibility to create an instrument that can hear cases brought by individuals and compensate individuals themselves, that can be brought by states, and can also be brought by other international organizations or states in the region, and can also hear very different kind of claims in the sense of that derive from different sources of international law. So I mentioned at the beginning that here we have a situation where many different kind of violations occurred. Violations of international humanitarian law, of international criminal law, human rights, international economic law, and many different kinds of law, many different kinds of violations, and so many different kinds of claims also. And an international claims commission, I think, would be able to be flexible enough so to hear all these different kinds of claims also, coming from many different kinds of violations. And what a claims commission does also, in addition to being very flexible, can provide, and you notice also the International Claims Commission are normally created in the aftermath of war, of a very significant event, disruptive event under international law, and can provide also other functions like provide a record of what happened and provide a certain amount of remedies in that sense. So provide a record, acknowledge what has happened, and also can ensure that also the peace in the situation is remedied and preserved. So I think the instruments, claims commissions, is a very interesting instrument. And so how can you apply in the situation here in Ukraine? How would you do it? What are the most interesting aspects of this? So here, first of all, again, you will have many different kinds of claimants, because you have claims from individuals. For example, claims from individuals that they were displaced. We know that there is a very substantial number of people of Ukrainians that had to flee, either Ukraine itself or were internally displaced. They also were, because of the action of Russia, also suffered loss of property, loss of livelihood, and injuries themselves. So how would you go about creating a claims commission for Ukraine? We know that there are many different kinds of claims. We know there are many different kinds of claimants, because in addition to individuals, we also have claims by the state itself because of the damages that Russia caused. And so what would be the right venue, the right way to do it, and what has the international community done so far? I think the international community has actually been extremely interested in finding a solution, because this has been such an egregious violation of international law. And I think here we really have such a blatant aggression, and this is really one of the worst kind of violation of international law. So how do you go about it? As I said, unfortunately, the Security Council is not an option, and so we will not be able to follow the UNCC path. There's no possibility of having a resolution of the Security Council. And at the moment, an international treaty, which is how the Eritrea-Ethiopia Claims Commission and the Iran-US Claims Commission Tribunal were created, neither of those really seem to be an option. But here it's quite interesting that the General Assembly of the United Nations has actually intervened, and within the Uniting for Peace resolution, this is a mechanism that really dates back to 1955, but allows the General Assembly, when the Security Council is unable to meet because of to perform its duties of ensuring security, this General Assembly can act in kind of trying to provide the same functions and substitute the Security Council, which I think is very interesting. And this has been used a couple of times already, I think 11 in total. And the Uniting for Peace resolution can be triggered either by a vote of the Security Council itself, which is a procedural vote, so it's not submitted to veto, or by 2/3 of the General Assembly. In this situation, it was actually the United States that suggested the use of the Uniting for Peace resolution, and that triggered the calling of an emergency session of the General Assembly. And in the General Assembly in this emergency session, the General Assembly then declared and found on the resolution that Russia had violated international law and was an aggressor, which is really quite significant. But more recently, on November 14, they went even kind of went a step further, and in a resolution called L62022, entitled "Furtherance of Remedies and Reparation for Aggression Against Ukraine," supported the creation of a registry for damages. First of all, actually, it spelled very clearly that a violation of international law, when there is a violation of international law, there are some consequences, and these consequences include provision of reparation. And this was very well spelled out by the resolution, which I think is quite interesting. And so creating an obligation to provide reparations to Ukrainians and Ukraine. And then said that, well, actually, one way to go about it is to create and give support to the creation of a registry for damages. And this is something that the General Assembly has already done once in application of the finding of the judgment of the advisory opinion of the International Court of Justice on the wall in Palestine and Israel, where the General Assembly created a registry for damages to register the damages that occurred, with the view of them providing damages and reparations and compensation. And here we are kind of in the same framework. The General Assembly gave support for the creation of a registry of damages, which would be a first step to then create a claims commission. And the first step would be, so we know what the damages are. We know we can find we have a registry that says these are the kind of damages, this is the amount of damages. And so we have the first step to create a system that would provide liability for Russia. I think I have about my 20 minutes. So this is I very much look forward to actually your talk and now seeing what can we do? Because of course, we have now this mechanism and this support, and we have to create it and decide how do we go a step forward and create the compensation commission itself after the registry for damages. And of course, where do we find the funds that would provide that compensation for both individuals and states. So thank you. I look forward to your talk now and then the Q&A. Thank you.
Thank you very much, and thank you for finishing on time. This is unprecedented. Brian, are you
I was
ready?
looking at the watch.
Right. Okay, start the clock. Thanks everyone for coming, and thanks to Chiara for those great comments. I'm going to be hitting on a much more lowbrow topic here, which is where do you find the money to pay these claims? Show me the money, as some people say. And this is the age-old problem in every compensation commission mechanism going back through the centuries, really. And I think of you can break compensation mechanisms and where do you get the funds roughly into two. We all agree that Russia should pay the funds. One bucket would be a consensual reparation process where Russia agrees to pay the funds. Another bucket will be non-consensual. And before you laugh me off the stage for talking about consensual, let's spend a moment there to start. There actually have been circumstances where a country who has committed violations of international law, for one reason or another, has agreed to pay reparations to the people who have been harmed by those violations of international law. The UN Compensation Commission might be one example. You have a new government who steps in, who agrees or somewhat agrees to allow its funds to be paid for claims. In the United States, the U.S. had negotiated not very long ago a compensation settlement agreement with Libya in the 2007, 8, 9 era, where Libya, which was interested in, at that point, rejoining the kind of common community, international community of nations, wanted to get off a U.S. terrorism list, paid about $1.5 billion to the United States government as reparations for victims of certain terrorist activity that the Libyan government had sponsored. So there are examples. Is it easy? Is it? No, of course not. One of my favorite examples in this space is with respect to U.S. claims against Cuba, which date back now 70 years to the Castro Revolution, where the U.S. has a claims commission, the Foreign Claims Settlement Commission, that very carefully preserved claims in the 60s and early 70s. Several $1 billion of expropriation claims involving Americans who had property in Cuba that was taken during the revolution. When I worked at the State Department, one of my jobs was to negotiate a claim settlement with Cuba. And you can imagine how successful that was. So we had a couple of meetings, one in DC and one in Havana, where I and my team came to the table kind of like this. Cuba on the other side, and we very carefully presented our claims that were very well documented, and we arrived at a figure with compounded interest and said, here's what we believe would be a just settlement of these claims. And my Cuban counterpart turned to me and said, it's very interesting, Mr. Egan. We will take this under advisement. We would now like to present our claims. The Bay of Pigs invasion is one of our claims. The illegal U.S. embargo against Cuba is another claim. So here are our claims. And when you agree to settle our claims, we'll agree to settle yours. So that didn't go very far. Okay, so, but it's possible. Russia could, there could be a change in government. There could be a desire by Russia to get out from under the sanctions that are in place all over the world against Russia that could lead to at least some negotiations involving a claims mechanism. Let's put that aside, though. Let's assume that Russia is not going to agree to anything close to what people are estimating even today, or some people say over $1 trillion in property and human damage in Ukraine from the conflict. What do we do if Russia won't agree to pay or won't come close to agreeing to pay that amount of money? What are the prospects for non-consensual reparations? And people all over the world, the news media, the US Congress, governments in Europe, in Asia have seized on the massive amounts of property that have been freezed by sanctions on Russia over the past year. Really, the sanctions effort against Russia has been unprecedented in many ways. It's not a UN-led effort because Russia, being a member of the Security Council, would never allow that, of course. But the coordination between the European Union, the United Kingdom, Canada, Japan, Australia, the United States has resulted in really tough sanctions against Russia, Russian government entities, so-called oligarchs, very wealthy Russians who have ties to the Putin regime, some Russian companies, Russian banks that have many impacts. But one of the most significant impacts is that property belonging to these people and entities has been frozen in banks in the United States, in London, Geneva, et cetera. We don't know the total amount of frozen assets, but it's estimated to be somewhere north of, I think, $300 billion US. So a very substantial sum of money that could go a long way towards compensating victims of these international law violations from the war. So it's a no-brainer, right? We just use that money to pay the claims. That's a matter of fairness. Unfortunately, I don't quite see it that way. I think it's going to be more complicated. I do think that money could be part of a solution, but I think there are several, I'd say 3 or 4 key issues to work through. One, just thinking about the U.S. domestic law perspective, which is where I've focused, and what it means to seize or freeze funds. I gave away my punchline. Freezing is not the same as seizing funds. So the theory of economic sanctions, this is not just true in the United States, but it's true in Europe. It's true when the UN Security Council passes sanctions, is we will freeze economic assets of the bad actors until the point in time when we can either convince them to change their behavior, they die, we are convinced that our sanctions were erroneous, there's some change that would allow the assets to be unfrozen. Sanctions are, by design, or at least as a technical matter, not supposed to be punitive. They're supposed to change behavior. And this is the purpose of asset freezes. It's different than an asset seizure. So an asset freeze, when an asset freeze takes place, a bank literally, Bank of America, puts in place a freeze account. They have special accounts set up all over the world where assets that are subject to sanctions are frozen. They collect interest. The theory is that someday those assets will be returned to their owners once the sanctions are lifted. And that's pretty much how sanctions work in every country that has been administering the Russia sanctions program. Why is it this so? Why do we freeze and not seize? Well, there's the theory of sanctions, which is that they're not supposed to be punitive in the long run. They're supposed to compel a change in behavior. In the U.S., it's a domestic law matter. It's also a little bit of a separation of powers issue. Congress gave the president pretty broad authority under a law called IEPA, the International Emergency Economic Powers Act, to, when the president declares a national emergency, he or she can do a wide range of things economically in response to that emergency, including imposing sanctions. And one of the president's powers in imposing sanctions is to freeze assets. This law, though, because when it was passed, Congress was somewhat skeptical of the president and executive power, does not allow the president to seize assets, to actually take the assets from the person to whom they belong, unless there is an ongoing armed conflict, essentially, involving the United States. And so there's a domestic law limitation in the United States on the Biden administration, in this case's ability to take the assets that are frozen under U.S. law. So there are some exceptions to this rule. One is the Justice Department, when there is a crime connected to frozen assets. So let's say somebody who was subject to sanctions tried to sneak their assets into the United States illegally. Those assets were discovered. They've been frozen. The Justice Department can bring a civil forfeiture action or a criminal forfeiture action against the assets that could result in the property devolving to the United States government. And that's not just true in sanctions, but it's something that is You may have heard some cases here in the United States where yachts and aircraft have been seized by the Justice Department. It's under one of these theories. The yacht violated U.S. law, probably by sailing into U.S. waters as blocked property or frozen property, and therefore the Justice Department seized it. That's one theory that's available. I don't think that will help the problem that we're talking about today, at least the way that these forfeiture laws are currently written, because when property is forfeited to the United States under these laws, there are very specific and constrained limitations on the use of such property. Essentially, property forfeited to the U.S. government under these laws needs to be used either to reimburse the law enforcement agencies in their efforts to take the property or to go to other law enforcement initiatives. So that's a matter of U.S. law. That could be changed. Something that Congress could do. They could say forfeited property in this context could be used for other matters, but that would require a change in law. There have been cases where Congress has, seen a problem of some sort involving frozen assets and said, well, we know the normal rule is you can't seize, but in this case, we're going to make an exception. For example, there has been a law that was passed allowing access to some frozen Cuban assets to resolve claims by U.S. nationals against Cuba. There's been another law that was passed to allow access to assets of the Central Bank of Iran in certain circumstances, again, to resolve claims by U.S. claimants. There is another law that allows access to victims of terrorism in the United States with respect to assets that have been frozen from terrorist parties. So there are some precedents for where Congress will say, we know in normal circumstances, sanctioned assets should remain frozen, but here, for reasons X, Y, and Z, we believe that rule should be changed. Would that be a good idea? And I should say, similar conversations are going on, I think, in Europe, where people see probably a much greater pool. Chiara and I were just talking about this before the panel, a much larger pool of assets. They're right on the doorstep of Ukraine. They're seeing much more closely what's going on a daily basis. Why can't we use these seized assets as reparations for some of the harms that are going on? Maybe the answer is yes, at least partly, but here are some of the complications that I see. One is an international law complication, and this ties to the fact that the frozen assets are partly Russian government assets, but I would guess majority not Russian government assets when the dust settles. I think the majority of the assets probably belong to either individuals or companies or banks who have been sanctioned. It's much easier to put a party on a sanctions list, I can say from experience, than it would be to prosecute the party for having committed a crime. So a wealthy Russian individual who is added to a sanctions list as an oligarch of the Putin regime, that person may have legitimate arguments that their assets shouldn't be seen as the same as Russian government assets. You may say they don't have legitimate arguments, but that is an issue that you would have to wrestle with. Is many of these assets are not actually Russian government assets; they belong to other parties. And would you want to, lump all of these assets together into the same bucket when thinking about reparations? Second is, I'd say, an issue of reciprocity. That if the Russian government were to see the U.S. and the European Union governments and the UK and the Japanese government seize assets belonging to the Central Bank of Russia, for example, or Russian companies or Russian banks, a Sberbank around the world, what would stop Russia from doing the same? My view is those arguments can kind of have limits because Russia's already committed some pretty heinous violations of international law. Why would we think they'd be a responsible actor here? But I think that would be another consideration to work through in thinking about how to deal with blocked assets is what would likely be the response of Russia? What would be their justification in doing so? And can you, formulate a plan with seized assets that would take those things into account? Third would be, I think the impact on Russia itself with any plan. Again, we're here mostly thinking about Ukraine, but if a compensation plan is too punitive, I think you've got to also have in the back of your mind whether this will go too far and put Russia in a position where they will never recover, and this will result in even worse things emanating from Russia in the future. So I think that's something that's got to be on the table, as well as governments are thinking about what to do with frozen assets. So Dan, why don't I stop there and turn it back?
I'm going to ask each of you to comment on the others, but I had a couple points to make. One is in the UN Compensation Commission, one of the heads of damages was environmental. And that's also a head under the Fourth Geneva Convention, that harm to the environment is compensable under international law. And we did that with the UN Compensation Commission. I was at EPA then. We submitted a claim for, I don't know, $100,000 or something like that for the amount we had spent helping clean up the environment in Kuwait. But that could well be something that a claims commission could look at. And it goes to Chiara's point that the claims commissions can be very specific in what they're doing. They can be very careful in looking at particular types of claims. But there are real valuation issues. One thing that Russia did in the Ukraine is destroyed its seed bank, which actually hurts all of us. Seed banks are part of the common heritage of humankind. They're not just owned by the country where in which they reside. And how would you value that sort of thing? I mean, those seeds are gone. We may have lost some species that way. And so they're real valuation questions, but a claims commission can at least approach that. Another point I don't think you mentioned, but you alluded to in a way, was that sometimes even if there isn't compensation for the victims, it can matter in terms of their feeling of justice, that there's an acknowledgement, I think was the word that you used, that they were treated unjustly, and that's recognized, even if they don't receive funds in the end. So those are 2 points. The third is that these votes in the General Assembly are very interesting. The reparations vote, fewer than half of the members of the General Assembly voted in favor of that resolution. 94 out of 103 members of the UN. And earlier votes were higher, and none of them were close to unanimous. So you wonder, well, what does that mean in terms of support for this sort of approach? Have less than half the countries in the world supporting it, and some of the ones that didn't support it have a lot of people. China, India, Indonesia. So that's just a point I wanted to make. Could I ask, before Chiara comments on your comment, Brian, could you say a little bit more about central banks? Because I don't know if the 300 billion figure includes funds that are in central banks and the peculiar difficulty there of going after funds.
Yeah, so I think the 300 billion does include funds of the Russian central bank, and among other peculiarities about central bank assets, the U.S. has historically taken a very cautious approach to sanctions and central bank assets, because so many central banks bank here in New York. And because the U.S. sees great benefit in being the banking country of choice for banks around the world. So in the Venezuela sanctions program, for example, it took a long time before the U.S. government was willing to freeze Central Bank of Venezuela assets. So I do think that central bank assets pose a particular sensitivity for U.S. Policymakers. I think that's also true in the UK. I think that's going to be true in EU countries as well. I think understanding what the universe of assets is beyond central bank assets will be an important part of this exercise.
Sarah, do you want to comment on?
Yes, thank you. Thank you very much. These are excellent questions and points. You're right that the UNCC also included a lot of environmental claims, and those were billions of dollars also for make the oil installations explode and damages to the sea, the air, and land. And the UNCC itself had a team of technical experts that made evaluations and ensured that the evaluations was correct. So I think that the point of evaluation is a very good one. In terms of the votes of the General Assembly resolution, the General Assembly 6, I think it's quite interesting what you said in terms of who voted, and I actually have the break-in of the votes, which is less than the resolutions that condemned Russia for aggression, which I think is quite interesting. But for the furtherance of remedies and reparation resolutions, we have the resolution itself was sponsored by 56 member states, and then 94 votes in favor and 13 against. So we have about 74 that abstained, but I think it's quite interesting if you look at the reasons for the abstentions, which wasn't really very much linked to the idea of reparations, but maybe more linked to the fact that for some the similar situations were treated differently, so that you have reparations here talked about for Ukraine, but there had not reparations for other previous violations of international law. So to my understanding, most of the abstentions were caused by that rather than something specifically that in relation to providing compensations of Ukraine. Your final point about the different ways, the different functions of creating a compensation commission, I think you're very right. You have many different kinds of reasons. One is compensation, but you also have many others, historical record and providing support and many others. I loved your presentation, and I have several questions for you. So thank you. One is so I think you're right when you say this, that sometimes we have situations where you have an agreement. I don't know if you can really say that Iraq agreed, right, on the UNCC, but certainly they had to do it, and eventually they had to do it. But I think the example of Iran-US Claims Tribunal is actually quite interesting, because there was no possibility until actually the treaty was signed, but not signed together. You know, there was always the intervention of Algeria, which I think is very interesting. There, the situation changed very rapidly, with Iran wanting to find a solution very rapidly, but very unexpectedly. So I think it's interesting. Where will there be a situation where we find Russia coming at the table? It's possible. There might be a situation that changes completely, and then we will have maybe an Iran situation again. Maybe the need for funds, they need to be part of the international community again. But this is quite interesting. The other, I think, that also mentioned. So I don't think there's anybody that says that freezing the assets is, violates either international law or domestic law. So we all agree that freezing the asset is fine, and both under international law, maybe as a countermeasure, and in domestic law. So the problem now is what to do with these frozen assets. How can you use these frozen assets? Because under international law, you're not supposed to. Countermeasures are supposed to be reversible, so you're not supposed to spend the money. So how do you go about that? And I think this is the question. And is it different with international law and domestic law? I think in domestic law somehow it might be easier, because then you can just change the law. But of course, you have different difficulties depending on where you are. So I think the situation in the US is different from what you have in the UK and in others. But this is a domestic part. So what do you do with the frozen assets, and how you can actually have access to those funds and use them? And is the possibility, and this is very theoretical, but I would be very interested in hearing what you say and what you say also. So if under international law there is an obligation to pay reparations, and you have these funds, and if the crime of aggression is a crime that's being committed and is a jus cogens and creates erga omnes obligations, is it possible to say that using those funds is actually kind of implementing the reparation that Russia is supposed to do, but they're not doing, and so they're enforcing international law by countries are providing reparations, and they're actually respecting international law and specifically the erga omnes obligations. So, in a sense, of fulfilling Russia's obligation to provide reparations. And so it was very interesting to hear what you say. The other questions that I have, I am surprised that you haven't said anything about sovereign immunity, because I think that was the biggest obstacle. And if you don't find it's an obstacle, I'm kind of relieved. But so I'm interested to hear your point on sovereign immunity. Is it an obstacle? Is it not? What kind of possibility is it? Is it not because here we're not talking about a court, but what are the consequences also? So it'd be very interesting to hear why you haven't cited it, or if it means that maybe you don't think it's an obstacle.
Yeah, those are great. Those are great questions. I think starting with the Iran U.S. Claims Tribunal, it's kind of an interesting model, maybe a bit of a unicorn. I don't know, because both countries and their nationals so clearly had claims against each other that they wanted resolution of. But you're right that there was a very rapid change on the Iranian side that led to the adoption of the tribunal, which remarkably continues to this day. But that's a good example that even when you have two clear adversaries, there could be a kind of a common ground that could establish some sort of a consensual or pseudo consensual process. I do think that international law will play a major. It will present major challenges in seizing sanctioned assets unless there's some sort of a Russian consent or non-objection to doing so in certain circumstances. And it's probably more so going to play out in Europe than in the United States, just given the nature of our legal system. If domestic law considerations typically trump international law, customary international law considerations, but certainly from the perspective of countermeasures, seizing assets, I think it's pretty commonly considered to be something that is not an appropriate countermeasure for the reasons that you said. I also think that sovereign immunity issues could come into play in the United States as well. That's one of the other complications with seizing government assets here is the unique defenses that governments can make in some circumstances in defending against seizure claims. And I think that the breadth of challenges under U.S. law to seizure claims will be much greater than they will be under freezing claims. Basically, when assets are frozen under sanctions, the U.S. government is kind of like the Harlem Globetrotters in court. They never lose. They can freeze. They can decide to freeze for many different reasons. But when they seize assets, it's a different story. There are constitutional issues that could come into play. And for foreign governments, even if they can't access constitutional issues, they may have access to other issues. And I think those issues play out even more in Europe and in Japan than here in U.S. courts. I think you raise a good point too, and I welcome Dan's views on this too, on whether jus cogens violations, erga omnes obligations under international law kind of would change the dynamic in some way on some of the international law issues and make it easier for certain states to come on board and to address the precedent issue that I think is kind of the counter to what does this open the door to in the future. So I think that should be part of the discussion here as well, as if we are going to create an exception to the normal rules, what justifies the exception? do we have precedents that we could cite to that are consistent with this exception? How do we see this exception going forward? That should be part of the discussion there too.
Yeah, very interesting questions. Your point about that in the United States, it ends up being domestic law that trumps is correct. And so if Congress decided that this was a terrorist country, and by the way, the Ukraine's other case in the International Court of Justice is not under the Genocide Convention, it's under the Terrorism Convention. And it's arguing in that case that Russia is supporting terrorism because of its support of the forces in eastern Ukraine. And this dates back to, they filed the case in 2017, I think. So if the ICJ were actually to hold that it was a terrorist country in that sense, I could imagine the U.S. Congress jumping all over that. The point or the question you raised about should somehow this trump other human rights, the right to hold property and that sort of thing, sort of forcing Russia to tax its own citizens or something, and then you get the money from the Russia, so a legal fiction. I'm uncomfortable with that, partly because of the hypocrisy or the disparity in treatment of countries. I mean, in my view, this is not so different than Iraq. The second time, we had one person that decided to invade Iraq. He got other countries to help. I mean, Russia only has Belarus. We had more countries. Turns out the reasons for going into Iraq were fabricated. But and the Russian ambassador to Kenya actually raised this with me in last March, because I was drafting a civil society statement about environmental damage. And he said, well, you can't say this. I mean, you didn't say it about Iraq. And I said, well, actually, I felt that about Iraq. But the fact that we didn't say it about Iraq doesn't mean we shouldn't say it now. Right? I mean, if it's the case. So, I mean, there really is a disparity in treatment that we have to think about. Now, Iraq and Ukraine are not exactly the same. I don't mean to suggest that, but they're in the same realm, I think. But it's a very interesting question, and it's pretty profound. If you went the way you're suggesting we might go, that would have profound implications, I think. But let's open it up to the audience here. I mean, I have other questions. This guy has a bow tie on, so we've got to call him. Yes, sir. Would you identify yourself and your affiliation? We've got a microphone for you, and then if you just keep your question to 2 minutes, that would be great.
Sure. Admire your bow tie game as well, sir. This question is for Mr. Egan.
And your name is?
Oh, sorry. Yes. My name is Connor O'Brien. I'm an alum. I graduated last year. Mr. Egan, when you mentioned the slim possibility of consensual reparations, I had to hold back laughing you off the stage, unfortunately, because when I look at Russia, it's a country that has committed a genocide against Ukraine within living memory, the 1930 Holodomor. And you mentioned, the possibility of regimes changing and that making eventual consensual concessions possible. But the Russian attitudes towards Ukraine, they're not centered in the leadership. These are widespread views towards the Ukrainians. I've talked to so-called, moderate Russians educated in the U.S., and they've told me things, I don't want to go into anecdotes, but they've said, Ukraine's not a country. It's a made-up people. So I don't really view that as being possible in the future, because we're never going to conquer Russia. They've got nuclear weapons, and the Chinese, who are committing their own genocide right now, are always going to fall in behind that, not to create precedents. So might it not be more possible for, and I'm not an international lawyer, so I'm not going to go into the seizure versus freezing assets, but would it not be possible instead for a coalition of countries to say to Russia, look, we're going to maintain these sanctions, we're going to maintain visa blocking, we're going to boycott you at the Olympics, et cetera, until you provide a fund that you can calculate to Ukraine as reparations. Will that not be instead a more viable option? Long term, perhaps, but I'd say the punitive nature of it doesn't come close to what they've committed in Ukraine, but as in the right spirit. Thank you.
Yeah, that's thanks for that question. That's a great question, and I actually think that when you're thinking about consensual reparations, that would be the type of quid pro quo that could lead to something on the Russian side. I think the sanctions are having a substantial impact on Russia, notwithstanding what some in the regime may say, and Putin on his worst days admits as much. So I think that the countries who are imposing sanctions actually have a fair amount of leverage because of the sanctions that are in place. And that could be the basis for a negotiation, along with perhaps other things, as you mentioned. Could the negotiations lead to some of the frozen assets, Russia agreeing or not objecting to the use of those assets for some sort of a compensation mechanism? That's one possibility that would also resolve some of the international law issues that we've been talking about. I think that's the sweet spot, and frankly, I think that's that would be consistent with the purpose of sanctions, which is to kind of somehow bring about a change in behavior in Russia. Ideally, this is leading to the end of conflict and leading to other changes that governments could demand with sanctions being lifted. Is that going to be an easy lift? No, not even close. But I think that there is space for discussions in that area. And you look at other examples, the Iran nuclear deal. Sudan getting off of the U.S. sanctions. Myanmar, Burma, being released from U.S. sanctions, now back on the list. There are examples where governments who have been at odds have used sanctions as the basis for negotiations to at least resolve some part of disputes between countries.
Well, the Litvinov assignment in 1933 with the Soviet Union. Dan? Whoops.
Daniel Serwer, I'm a professor here at SAIS, but I'm not a lawyer. And so I'm going to ask non-lawyerly questions. First, I have the impression we're doing something with Afghanistan's frozen funds, and I don't think that's been mentioned. What are we doing and how do we do that? The second comes from my experience as a State Department officer, admittedly many years ago. The strongest argument against paying claims against frozen assets, I was involved in an effort to do that with the Libyan assets, to pay claims of the victims. The strongest argument was Treasury. You worked at Treasury. And the argument was that will undermine the entire international financial system by undermining the confidence that the U.S. is a reliable partner. You mentioned that argument. What I'd like to invite you to do is to counter that argument. What would you regard as a good argument against the Treasury position?
So I actually had the benefit in my time in government on sitting on both sides of that argument, Treasury and then at State. So I've had to do some of that. First, on your Afghanistan question, you're right that the Afghan central bank assets here in the United States have been frozen. And that's in part because of the Taliban's control of the Afghan government. And one of the points of negotiation between the United States and Afghanistan has been under what conditions will the United States allow the current regime to access those assets? What will be the conditions tied to that situation? So I think that's another example of sanctions, the pretty specialized set of sanctions in that case, being at least a basis for bringing parties to negotiations. With the Afghan central bank assets, as I understand it, that's been something that's been under discussion, including with Congress. I'm actually not sure if we've accessed those assets for payment. Maybe you know,
I don't know
Chiara.
if I don't know if you access, but I think that the sum was split in two.
That's right. Yeah. That's
but-
been part of the discussion.
Right.
Is
And then this part of it would be used to compensate domestic claims, if I remember correctly. But this will be again in the scenario volunteer agreement, which is one scenario. Yeah.
or at least volunteer in air quotes agreement.
Yes,
to
of
say,
course. Yeah, it's the pressure.
This is what it will take.
Yeah.
I think that using frozen assets to pay claims, the other side is really a fairness and justice argument, in my view, which is why should we, as a defender of human rights, of international law in the United States, of victims of atrocities, not side with individuals who have been harmed by in situations like the invasion of Ukraine against preserving, the international financial system. I think that's one, is just a basic fairness argument. Two is just a precedential argument that now we've got several examples where frozen assets in the United States, at least, have been used primarily to pay American claims. And there are political considerations behind all of those things as well. But our system hasn't come crashing to a halt as a result of the payment of those claims. I think this set of circumstances would be bigger than the ones we faced even when you're thinking about the Libya frozen assets. So, I think the argument it'd be a more serious argument here, but I think if we were part of a coalition from a U.S. perspective, where the Europeans were accessing under some formula, here are the assets we're going to access, here are the ones we're not, here's our basis for doing so, here's the evidence we're going to require for claimants to be paid. If Japan were to come along as well, I think that kind of takes some of the air out of the tires of the argument that this is going to really impact the international financial system.
I may add to that. I think it's very important what you said, because I think a process of compensation has to be an international process that follows the international standard. And I think it would also have to allow Russia to enter at one point. If they wanted to enter and they decided that they want to be part of this, they have to be able to enter. But I think maintaining that international standard will give legitimacy to any kind of process. So I think the fact that having a coalition would be a very important one. You cited also this, and I think your questions also was about, consensual, semi-consensual. And in the Iran-US claims tribunal, I think what is interesting is not all of the money was frozen and used for reparation, but there was a creation of a fund. Most of the fund was unfrozen so that Iran could use it, and some of the fund was put on aside for compensation, and that Iran had an obligation to continuously replenish to up to 500 million for a certain amount of time. I think your question about using different standards is a very legitimate one, but it's why do we want to stop? We don't want to stop providing reparations for Ukraine just because we haven't done it before. I think we should create a system that provides reparation for victims of war that exists all the time.
Yeah, well, that was the argument. Argument I made as well. For those of you who don't know, this gentleman, but why don't you take the mic to him? But let me just say, for you, those of you who don't know, what we're referring to about the U.S.-Iran agreement was that neither country would talk to each other. So we each made the same agreement with Algeria. The obligations all were to Algeria, not U.S. to Iran or Iran to the U.S. And it's just an example of how one has to think about, well, what will work essentially over time. And your point is a really good one. We don't want to back off too much on these issues. I mean, these are as basic as they can get. Trying to change territory by the use of force. The kinds of human rights violations that are occurring, violations of all sorts of law of war instruments and that sort of thing. So we don't want to back off from that. But the whole game here is to figure out how to do it in a way, so that people are compensated and feel vindicated. Sir?
Hi,
and then Ken.
my name is
Earl.
Cameron Vega. I work at a congressional agency and I'm also a student here at SAIS. My question actually builds right off of that. So we kind of talked about the complexities of this specific Ukraine-Russia case, but it was broadly generalized, both with an explicit and implicit reference to use Kogan's. How can debate or consideration of sort of future thin institutional framework, not quite the ICC, not quite the ICJ, but one focused on use Kogan's violations and financial recompense for them, how can that conversation be situated for the future, for not just Ukraine and Russia, but after it? Should there be a greater international legal mechanism for dealing with financial reparations and financial repercussions for crimes that's not just sanctions? Should it happen? What are the considerations? How does sort of state sovereignty play into that?
It's an easy question. I'll take it. Yes, I mean, there should be a mechanism, yes, but the problem is how to create it, and that is the difficulties. I think what we are seeing, a lot of interesting development now actually going on in international law. So moving from the aggression here, I think is quite interesting to see now all what's going on also about climate change and these advisory opinions that are coming up to the International Court of Justice and ITLOS and others, saying if there are these kind of violations, if there are these damages that occurred and injuries to people, what is the role? What does the international community have to do? What do states have an obligation to provide? Do we have to provide certain reparations? So I think there are lots of interesting discussions to be had on this. I think use cogence, of course, violations of use cogence should take priority, but I think the problem is how to do it, how to provide reparations.
Yeah, I almost think those are two different questions. This might be an area, go back to what you said about acknowledgements of harms. You know, if you might think about a mechanism for acknowledging use cogence violations as separate from the question of reparations. It could be done on a step-by-step basis. So I think reparations is going to be hard. Creating a pool of funds from the international community that can be called on to, provide compensation to victims. That's going to be a tough place to start, but I think there's going to be much greater agreement on, we should have a body that could be responsible for just overseeing use cogence violations. I don't think that's going to be an easy issue either, but that might be a place to start on your question.
I wonder, Dan, you were at the IMO, and I wonder if because one example is is it called the oil pollution fund, right, where everybody chips in, and then when there's something that happens, then that fund is used. I wonder if that might be an interesting example to see, to explore.
It could, but the idea of having a fund to take care of claims that arise from countries attacking other countries is, my mind have a hard time seeing that, but there may be something there. And these are all interesting ideas. I think they're worth exploring. Sir, and then Ken.
Hi, and thank you for this. It's been very fascinating. I'm not an international lawyer, but a long time ago, I was an L for Legal Advisor's Office for a very brief period of time, and mostly went into policy positions. I'm a senior fellow here now, but I thought—
Could you say your name? I'm sorry.
Stephen Schrage.
Thank you, Stephen.
I thought some of the things that you raised about the consequences of going too far versus the justice really highlighted the tension between kind of legal standards and geopolitical issues and how you balance those. In particular, a lot of the examples were raised were relatively smaller countries in terms of the geopolitical context in a case law mentality versus Russia and what would happen afterwards. And kind of my thoughts went back from some of your colleagues to comments to more of like the World War I situation in Weimar Germany, in particular, how you would balance what would obviously, I think, are strong justice and legal arguments on behalf of the Ukraine people with what are the consequences geopolitically afterwards, especially if it's another government that suffered already under a lot of what Putin did. And so I guess the two questions are how you balance those, who balances those. I mean, who's in a position to balance the strict legal standards versus the geopolitical standards as a government or set of governments. And then I think as someone else raised, when you've got some of the most populous countries in the world, particularly China and India, being some of the hardest to convince on this point, if you are making that grand compromise between legal standards and geopolitical issues, particularly with Russia's nuclear capabilities, the largest stockpile in history, and the risks there if they're destabilized, how is that seen as legitimate when you may have a huge chunk of the world, if not the majority of the world, not exactly bought into whatever scenario is worked out at the end?
Okay, that's it's a wrap. I'll start. I think that is when you're talking about negotiating an international mechanism. I think those geopolitical considerations have to be on the table and will be on the table when countries are thinking about the appropriate, what mechanism, how much compensation is appropriate. Who should pay? Where should those funds come from? Should we be thinking about something that looks like a tax on Russia? What are the impacts of those of that? Even if you've got a coalition, let's say Ukraine wins, Russia leaves. Now they've been vanquished, and everybody agrees Russia must pay. I think these considerations very much will be on the table. I also think that China, particularly China, but also India, will play somewhat of a role in, even if they're not directly at the table, in helping to kind of formulate the boundaries of what this might look like. Because I think, take the United States, virtually everything we do these days as a foreign policy matter, we're thinking about China directly or indirectly in how we do it. And so I think our policymakers will be saying to themselves, how will China react? Will they see this as a threat to them? Will they see this as a threat to their own stability, given their border with Russia? A threat to the Security Council. And so I think that China most certainly will play somewhat of a role in this, even though they haven't agreed to the sanctions, they haven't frozen assets. I would also say they don't agree with Russia's invasion of Ukraine, even though they can't say it out loud. So I think they will be there in some ways. But Chiara,
I agree with what you said. That this may change some of the political balance, but it seems that they will all play a role. I just want to say something about what just not to correct myself, but just to make sure that I have not misunderstood. I think it's important in the issue of compensation and the issue of use cogents and everything that we're talking about. I think it is very important that we hold the perpetrator accountable, right? So the funds should not be coming from somewhere else. Fund has to come from Russia. So we don't want anybody else to pay. We have to find a way, and we don't want to impose those kind of sanctions for which nationals of Russia themselves would suffer. We have the funds, and a lot of those funds, as you said, are from the oligarchs, and maybe they don't need so many yachts, right? So I think it's important to think that, if a country violates international law in such a way, it has to be the country itself that pays. So I just want to make sure that my point before wasn't misunderstood.
I like that theory, but my guess is in the end, there'll be some sort of Marshall Plan as well, that the U.S. and other allies will be willing to contribute to help Ukraine. And you can argue that on humanitarian grounds, on the argument, well, we didn't do anything in 2014, so, we're sort of not to blame, but, anyway, my guess is it's going to be a combination. And I hope it's a combination, that is. I hope there's some part of the holding the perpetrator liable, but I think it's going to be complicated, I guess. Ken, and then this, yeah.
Ken Reisenfeld at Baker and Hostetler. I lead our investor state arbitration practice. Dan, I wasn't here at the very beginning, and so I didn't hear whether part of your intro, you dealt with these two factual issues, which I'd like to raise, and then I want to raise a broader question. But one of the factual issues, Brian, I had thought in the omnibus bill that there was something that allowed the forfeiture of assets be paid as reparations to the Ukrainians. And I don't recall, I was in the middle of hearings at the time, so I didn't read the details. So, but I assume you probably know about that. And Chiara, my factual question for you is, I understand that there is a process now going on in civil society trying to bring together a group of people. Patrick Pearsall, I know, is involved in it, and I knew you are. Maybe you could describe what that process is and what the status is of it, so we know about that. And the bigger question, and Dan, I'm sure you could weigh in on this, is what's wrong with setting up a registry now? I mean, the Foreign Claims Settlement Commission was very effective at making sure that the evidence didn't go stale and that they were able to have a uniform standard applied to all claims. I know that in Ukraine right now, a lot of Ukrainian farmers and others whose property has been damaged, they're trying to figure out how to establish claims. So I guess my question is, why aren't we moving forward on the registry front, even if we can't figure out a mechanism for liability and payment?
Well, most of that's to you.
Yeah, yes. So, well, the omnibus is for you because I don't know about that at all. But yes, so the idea is exactly that. The idea is to go ahead with the registry and the registry of damages. And so now we have the support. The General Assembly has given the support to create this registry, and the idea is exactly that, to go ahead with that, and then to have a registry that tells what the damages have been, and then to follow up with the compensations later. And this is part of the effort that I'm working on with Patrick Pearsall and others, Jeremy Sharp and Marka Kierczlowski and others. And we are appointed by the president of Ukraine, President Zelensky, and so it's not really civil society. We are working on this, and the idea is exactly to try and find a way, but taking a step at a time, and the registry is the first one.
Yeah, I was tracking that being part of the National Defense Authorization Act. I just don't know if that was how it resolved, but this would, as I understood the proposal, it would be where the U.S. government, through a forfeiture action against Russian assets, was successful. Those assets could be used in some sort of a reparations process against for Ukraine. That would just, at this point, would be a very small subset of the frozen assets here in the United States. But still, I think, that's an example of Congress saying, well, we see the limitations we've imposed on the executive branch. Here's a way that we might resolve it. And I wouldn't be surprised if there are further initiatives along those lines.
One last thing, you may not have heard me say that the Human Rights Council on March 4th set up a commission of inquiry, and it made its report on October 18th. And it's right here, and it's online, and it's got a lot of details about specific instances of violations of human rights. It focuses on the human rights side, but of course it's the beginning of really finding evidence, writing it down, recording it, that sort of thing. So there are efforts going on, and civil society is also involved, but not in the effort that Chiara is.
The other actor is the Council of Europe. But there are many actors as a.
Sure.
Thank you very much for your presentations. My name is Alexander Moskalenko. I'm from Ukraine, city of Kharkiv, and here I'm a visiting scholar. So I have two questions, I think, to both of the speakers. Number one, so since diplomacy looks like the primary instrument to get the compensation, do you think that the issue of compensation somehow should or will depend on the military outcome of the war? And if it will, to what extent? And my second question is, about the special tribunal that the Ukrainian government promoting for the trial of high-rank Russian officials. Do you think this special tribunal, if it's ever created, will influence the issue of compensation, and if it will, to what extent? Thank you very much.
Thank you.
My understanding on the tribunal, and so that then at the beginning made a separation between kind of criminal law and compensation for the criminal process and the more of the civil liability. So in parallel to the compensation process, now we have this idea of also creating a tribunal, ad hoc tribunal for the crimes of aggression. There is at the moment a process within the International Criminal Court. Ukraine has accepted just for very specific for a specific situation, the jurisdiction of the International Criminal Court for the crimes that are being committed now, but this does not include the crime of aggression, so it's only limited to genocide, crimes against humanity, and war crimes. And so the idea is possibly to create a separate tribunal only looking for the crime of aggression. My understanding is that this is something that a lot of people are supporting, that is, and there's a possibility, real possibility that's going to be created. But I think it's going to be a parallel process. I don't think it's going to influence, in a sense, the compensation, because their jurisdiction will be very different. I don't know if you want to add anything to that, or
I just add that. No.
sorry, no, go ahead.
Mm-hmm.
Well, so it's not the
Will it depend upon what's going to be at the end of the war?
the compensation.
I mean, diplomacy has to do with the reality which we meet at the end of the war. So if, for example, Ukrainians win, and by the way, it's a big issue to understand what is the victory of Ukraine. I mean, should they capture Moscow? Should they go to the Pacific Ocean? I have no idea. But my point is like, how the issue of compensate is connected with the military outcome of the war.
Yeah.
I mean, will we discuss the issue of compensation of Russia if, for example, Russians capture Kiev and go to Lviv? Yeah, thank you.
Yeah, I think we have to see. Yeah, I mean, I'm sure that they influence each other. This is, but we have to see how the situation evolves.
Yeah.
But I think, I mean, under international law, it's pretty clear that on one side you can't recognize the annexation of territory, and that the reparation is due. But this is international law, and so I think, but this is very clear.
I think I agree with Chiara, but I also think you're right that diplomacy, to the extent diplomacy is part of the solution, which I think it almost must be at some point, the military outcome is going to be important. That, at some point there has to come, we're talking about processes, putting aside evidence and preserving claims, processes for resolving claims that almost by design can't take place until after there's the end of conflict. And so where we are at that point, I think will impact what the nature of a claims mechanism looks like. With that said, I completely agree, though, that the international law is on Ukraine's side in this matter, in terms of Russia's invasion of Ukrainian territory. So I think that it will be a much different outcome if Russia were to prevail than if Ukraine were to prevail, or we ended in some sort of a stalemate.
Well, we're out of time. I want to say that there is a secret panelist, and that is that I asked ChatGPT what the answer was, and happily, ChatGPT is not as nuanced as these folks. The only additional mechanism it supported was attack by NATO forces, which nobody here is, I think, has suggested. So, Jeff, because we're out of time, maybe we could take that your question afterward. But I want to thank our panelists for coming and for their thoughts on this. I really appreciate it, and